Back on the record, the time is 7:53.
And one last housekeeping thing, I need to mark as exhibit number 43, the notes that we had while I was examining Dr. EGILMAN that went through some of the history. And I think we missed one other thing. Number 44 is the hard drive that has all the documents, the hundreds of thousands of pages of documents, and we'll mark that as exhibit 44. Subject to that, I again pass the witness.
Ready? Dr. EGILMAN, when you were on direct, you made a reference to some secret information or secret documents that the NCAA had. Do you recall that?
Yes.
And at one point you were pointing to it's Exhibit 15, sources of information. You recall that?
Yes.
And you have here listed various sources of information. The first one's medical journals,
Yeah.
medical journal articles. Is that right?
Yes. That's one.
Is the NCAA the only entity able to access medical journal articles?
No.
The University of Texas can access medical journal articles, correct?
Yes.
And the team physician for the University of Texas between 1961 and 1967 and 1971 had access to medical journal articles, correct?
Yes.
Check to the form.
And the trainers for the University of Texas football team between 1967 and 1971 had access to medical journal articles, correct?
Check to the form.
I'm not positive about that, but probably.
They could have accessed them if they wanted to, correct?
Check to the form.
I don't know what their access to. The people on the medical faculty certainly could have. I don't know what the access was of trainers.
And in terms of medical meetings, the team physician could have had access to a medical meeting depending on, I'm not sure what medical meetings you're even referring to there. Can you tell me, are those specific to NCAA medical meetings that you're aware of?
No, there were no.
Check to the form. I certainly didn't understand the question. If you did, you can go ahead, doctor.
Those medical meetings refer to things like the American Public Health Association or the Neurologic Society meetings, things like that.
And so, for those kinds of meetings, the NCAA is not the only entity that has access to those kinds of meetings, correct?
Correct.
The University of Texas could have had access to those meetings as well, correct?
Check to the form.
Well, certain people at the University of Texas, yes.
And it's possible that the team physician for the University of Texas between 1967 and 1971 could have had access to those meetings, correct?
Oh, yes.
For medical textbooks, same, right? The NCAA is not the only entity that has access to medical textbooks, correct?
Correct.
University of Texas did too,
Yes.
and the team physician for the University of Texas did too,
Yes.
and the trainers for the University of Texas did too?
Them I'm not sure.
Okay. Trade publications, the NCAA is not the only entity that had access to trade publications, correct?
That's correct.
The University of Texas had access to trade publications.
Yes.
The team physician had access to trade publications.
Yes.
The trainers for the University of Texas between 1967 and 1971 had access to trade publications.
Check to the form.
I'm not sure about them.
It's possible.
Yes.
Same thing for general publications. University of Texas, physician, trainers, all could have had access to general publications.
Yes.
Company meetings and correspondence. Are you referring just to the NCAA's company meetings and correspondence?
Yes.
Okay, well that might be one. I'll give you that one. How is that different from internal company information?
Well, meetings and correspondence. Meetings are meetings. Correspondence are letters, communications back and forth on different issues. I went over some of them. In this case, it includes emails, things like that. For example, internal company information would have been the helmet study. That's a study NCAA did that no one else had access to.
The helmet manufacturers had access to it, didn't they?
Oh, yes, they did.
And do you know of anything that was stopping the helmet manufacturers from sharing that information?
Yes,
What's that?
they didn't want to get sued, and they were irresponsible. They didn't want people to know that the helmets they were making were defective.
didn't Riddell attempt to advertise based on the helmet manufacturer? I'm sorry, didn't Riddell attempt to advertise based on the helmet study?
Yeah, they misrepresented the helmet study in advertising, yes.
And isn't it true that the NCAA wrote a letter to Riddell telling them to stop that immediately?
Object to the form.
Yes. I don't know about immediately, but stop it, yes.
I don't know about what.
I don't know about immediately, but yes.
You testified on direct that one of the things that you're opining about is who knew what and when, right?
Right.
And I have up here Exhibit 16. This is NCAA's, this is what you represent to be NCAA's knowledge, right?
Not exactly. I said knowledge or information available to them.
Oh, okay, so it's just available to them. If that doesn't, just because it's listed on here and it's available, you're not necessarily saying that the NCAA knew it then?
I'm not, well, in some cases they knew it. The librarian deposition didn't indicate that they knew it or had accumulated it in most cases. I don't think it was produced in this litigation, most of it, but there may be references to it elsewhere.
And I don't want to get too horsey, but if this is how you're going to question him, you need to sit down, not stand up and question him, just like I had to do.
Well, I have to get the,
You can point at it from there, just like
yeah, but
I
I have to trade these out, and
then you can get up and do it.
I'm not going to go back and forth, Gene. Let me just.
You're not going to stand over him to question him. So you
I'm
can-
across the room.
You can just, I know, and you said I could read your text from across the room. You remember that?
You were saying, you were alleging.
So which
you
do
were,
you want to do? Do you want to sit down or not? Because we're not going to have you stand up to question.
Gene, I'm just trying to. I'm not over him. I'm across the room.
I'm not going to have you stand up to question.
I'm simply trying to go through the exhibits.
I'm not going to have you stand up to question him. We also gave you paper copies of those exhibits.
Let's go off the record for a second.
No, we're not going off the record.
I need both parties to agree.
Well, can we go off the record so we can put the Elmo back on? I'm not the one. I'm not the one forcing this.
Yes, you are actually.
I could have been burning through these right now. You're the one stopping me. Can we take a second and turn the Elmo back on?
That you said
the
you didn't-
videographer has to
that you
do
said
it.
you didn't want, right?
No, I would prefer to do it the way I was doing it. We would be
I'm
much
sure
further
you
along
would
at this
like to
point.
stand over the witness.
I'm across the room from him,
Mhm.
Gene. In fact, the
If you
camera can
want-
now see exactly where I'm standing.
That camera's. Yeah, I know. Just like it could see exactly where I was when you were trying to insult me by accusing me of reading your text.
You were telling me what I was doing on my phone,
Yeah,
and the only way,
common
Gene,
sense.
this is a waste of time.
Yes, it is.
Can we turn the Elmo on?
Of course you can.
How do we turn the Elmo
one
on?
There's probably a button. It's not a waste of time because you want to do it a certain way. I don't have to agree.
I'm not
with
the
what
one
you-
trying to do it a certain way.
Actually, you are.
I was in the process. You're the one stopping me.
Yeah,
It's-
to make you
it's
do
fairly
it
clear.
to make you do it by the rules. That's right.
There's no rule about that.
Really, you think so? I mean, and with all this you say you have to do, you've asked them all these questions already this morning. Could the University of Texas done this? Could the trainers have done this? This isn't. You've already burned through it this morning.
That is not true.
Of course, it's true. And the record will show that. You don't
The
think you
record-
asked
the
him?
record-
You don't
the
think you questioned? You don't think you asked him questions about could the University of Texas done this? You don't think you asked him that today?
Not about this. Not about these exhibits you just marked.
The ones that you've had in your hands for how long?
Since you marked them?
Every one of those documents you've had, your clients had for decades.
Not the ones that are in my hand, is what you just said.
Yeah, it's a summary of those documents that you
I'm
have
talking about these.
that we got from y'all after the Court of Appeals told you couldn't keep hiding them.
You were not hiding your summary.
Oh, of course
You
you.
were not hiding anything.
Well, I'd like to think you're versed on the documents. You didn't need our summary to help you.
I don't think y'all have not handed me all of the hard copies.
Do you have more
of this.
questions?
I need the rest of the smaller versions of the larger exhibits.
Or you can use the posters. Either way, but let's go. It's 8 o'clock at night. Let's go.
Is it all right with you, Mr. Egnorth, if I stand up to put the...
Of course.
Okay.
I just don't want you standing up while you're questioning. Just like I haven't stood over your witnesses.
We will take this matter up with the judge.
What? Whether you're allowed to stand over him?
Clearly not the case.
Oh, okay. I mean, if you want to
All right,
take it up
Mr.
with the
Ed-
judge, we can
All right,
stop.
Mr. Eagleman.
He's a doctor.
I'm sorry. I apologize. Dr. Eagleman. That was not intentional. This is Exhibit 16.
I just got you up now. I have you up now. It's on you.
Dr. Eagleman, this is Exhibit 16, correct?
I'll take your word for it. I can't see from here.
And at the top of this, you have NCAA knowledge, and then you have a list of documents, but I think you just told me that not all of this is necessarily NCAA knowledge. It's things that you claim were available to the NCAA. Is that correct?
That's how I described it during my testimony.
Okay.
It was either available or they had it, one or the other.
Can you tell me which of these the NCAA had and which of these were just available?
You want to hand it to me and I'll go through it.
You can't tell from right here?
I can't even see it from here.
All right. This is Exhibit 17. Is the back of this in the shot?
No.
This is the same thing. It's a board that says NCAA knowledge, correct?
Yes?
And the items listed on here are things that you claim the NCAA either had or it was available to them, correct?
Yes.
Let me ask you something, Dr. Eagleman. When you're looking at this material, what theory or technique do you use to review this information and determine what the NCAA knew?
Object to the form.
Well, new is just their documents, what they say in their documents.
Well, but what theory or technique do you use to review this information and reach your opinion that the NCAA knew this or had this information available to them?
Well, the available is, was it in the medical literature? Was it in libraries? The new was, it's in an NCAA document. The NCAA document says these quotes. So if it's an NCAA document, NCAA is a human being, as it were, as an entity. And if they have it in their files, they knew it. Because it was in their files, they wrote it, they created it.
But not all of these were in their files, correct?
Well, I don't know that. I mean, we know what the librarian said, and we know you can't get access to, I can't get access to that library, so I can't check.
Have you ever published an opinion? Have you ever published an article with your opinion on what the NCAA knew or didn't know outside of this litigation?
No, coming to a journal near you soon, though. Preview of coming attractions.
This is Exhibit 19. It's a list of, it says at the top, anti-warnings. You recall testifying about that?
Yes.
We spoke earlier, you've done tests in the past on the effectiveness of warnings, correct?
Yes.
Can you do similar tests on the effectiveness of anti-warnings?
You might be able to construct, depends on the anti-warning and the population, you might be able to do that.
Have you attempted to conduct any test on the effectiveness of the anti-warnings listed on Exhibit 19?
No,
Have you published any articles regarding the effectiveness of the anti-warnings listed on Exhibit 19?
no.
You stated earlier that the NCAA should list, I think it was all this information on their website. Is that correct? As a warning? All the information you've marked as exhibits as a warning?
Oh yeah, that would be a good idea. Not as a warning, but as a way of informing people about what was known when by them and what they did about it and why they did it.
Would listing items on a website now help Mr. Pletz at all in 1967 and 1971?
No. Sadly, no.
Can I tell Mrs. Pletz that's your argument in the case? Wow.
I'll put Exhibit 16 back up. Oh, I'm sorry. Exhibit 17. You see here on Exhibit 17, where it has the American Football Coaches Association,
Yes? 1937?
1937. Do you know if Coach Darrell Royal was a member of the American Football Coaches Association?
No.
If he was a member of the
In
American Football
1937?
I didn't say in 1937. I just mean in general.
Yeah.
Do you know if
Object
at
to the
any time?
form.
Do you know if at any time Coach Darrell Royal was a member of the American Football Coaches Association?
I don't know, but I assume he was.
And if he was a member of the American Football Coaches Association, he would have access to the information provided by the American Football Coaches Association, correct?
I don't
Object to
know.
the form.
Is it your opinion that the American Football Coaches Association secretly shared knowledge just with the NCAA and not its own members?
Object to the form.
No.
That's not your opinion?
Correct?
And I think we talked earlier, coaches at the University of Texas also had an obligation to protect the safety of athletes, correct?
Hold on. You mean the questions you said you didn't ask earlier that you're now asking again for the third time? I'm going to instruct him not to answer.
Dr. EGILMAN.
I just instruct him not to answer. You're not going to ask him the same question again. Your question says you already asked him.
Dr. EGILMAN, are you refusing to answer this question?
Your choice, doctor, but you're keeping us here at 8:30 to repeat a question you admitted in your question you already asked him.
It's based on an exhibit I didn't have at the time I asked it.
You didn't have the American Football Coaches
I
Association
did not
document?
I did not have Exhibit 17 when I asked it.
Wow. Whatever you'd like to do, doctor. I gave an instruction. You can follow it or not.
Why don't you repeat the question?
The coaches, including Coach Darrell Royal at the University of Texas, had an obligation to protect the safety of the athletes playing at the University of Texas, correct?
Yes?
And they should use whatever information they could get from the American Football Coaches Association to help protect the safety of the athletes, correct?
Yes?
Oh, Darrell Royal's not up there. Coach Darrell Royal was the head coach of the University of Texas.
Not in 1937.
Didn't say he wasn't.
Yeah, I know, because we don't want to have the facts accurate, do we? probably about 10 in 1937. By the way, did you know Darrell Royal died of Alzheimer's, they believe is related to football?
No, I did not, Mr. Eggwolf. Thank you for that tidbit.
Or when he played at the University of Oklahoma.
Dr. Eagleman, you testified earlier about NCAA motive, correct?
Yes?
And this is Exhibit 21, and you list off here a number of items that you say form the basis of your opinion about the NCAA's motive, correct?
Yes.
What theory or technique did you use to review this underlying information and reach your opinion as to the motives of the NCAA?
Check to the form.
I read the documents, and I used critical analysis of the documents to evaluate what they said.
The critical analysis that you used, is there some objective criteria in which anybody else could judge your critical analysis?
Sure.
What would that objective criteria be?
Well, you, for example, could challenge my opinion on any of these documents. And you could say, well, you said this document meant this, but it doesn't mean this because of A, B, C, or D. You could do that.
So that would be just me reading the document and having my subjective interpretation of that same document, correct?
Check to the form.
No, you could challenge my interpretation of what the document meant.
Based on just how I read it and say, I disagree with the way you read it, right?
Well, presumably you'd give a reason. Okay, you wouldn't just say, I object. You'd say, Dr. Eagleman, you said this said A, B, and C, and it doesn't say A, B, and C, it says D, E, and F if you read it this way. Or if you looked at, you said, I mean, there's lots of different ways to, I mean, I can give you some examples of how you can cross-examine someone, but this process, this is real peer review here, usually, not today, but in general. You know, these depositions it's real peer review. People go through my report, they check every citation, not like peer review in the medical literature, that doesn't happen. Okay, you have lots of resources, financial, and lots of people you can hire to try to undermine all the things in my report and all the things I say. And that's cross-examination is the most effective way of critically evaluating, my opinions.
You said peer review in the medical field is not a very high standard.
Not compared to this. Nobody writes a paper and sits for hours being evaluated by one or more people who've spent months trying to rip that paper apart, checking every citation, checking every sentence, checking every statistics. That never happens in peer review. Never. Repeatedly, people in the major journals, New England Journal of Medicine, okay, articles published by, for example, the head of cardiology at Harvard, all fraud. Darcy's the case. All fraud. Made up numbers. Published in the New England Journal of Medicine. Went through, quote, peer review. There are lots of examples of that. I published some of the examples of that. The Vioxx papers went through peer review, and the companies had hidden MIs and strokes and such and not put it in the paper, passed peer review. And that was in the New England Journal of Medicine. And not only that, Merck, who did the first Vioxx paper, got caught by me and others lying in the publication, and the New England Journal of Medicine published another paper on Vioxx by Merck, and they lied in that one too. okay? And they didn't catch that either. So this happens all the time in peer review. This process, much more thorough than peer review, absolutely.
And given this, what you're calling a very low standard, yet you have written articles and submitted to peer review journals, and your articles have been rejected, isn't that right?
Excuse me, it wasn't a low standard. I never called it a low standard. I said compared to this standard, it's a higher standard. This review, okay, is always better in my experience. And I was an editor for 9 years of a journal, so I've got some experience here. It's much more thorough than standard medical journal peer review.
Isn't it true that you have submitted articles to peer review that have been, medical articles to peer review that have been rejected, correct?
Sure.
Including recently, correct?
What do you mean recently? I don't think recently.
You haven't recently submitted an article to a peer review journal and it was rejected?
Not that I can recall, not recently.
When's the last time that would have happened?
I can't recall. Probably, the last one I remember is a OxyContin article in 2006. Normally they come back, you get comments, you send them back.
Do you know the legal standard in Texas for determining whether there is an employer-employee relationship?
Go to the form.
Well, I think I've reviewed that in the past, but I don't know if I haven't reviewed it recently. It may have changed. It's not a Texas standard for many purposes. For example, it's an NLRB standard in terms of whether you're an employee for purposes of organizing a union. That would be a federal standard.
And the NLRB opinion that you cite to, that actually applies to private colleges, correct?
That's correct.
It does not apply to public universities, correct?
Not as I recall. That's correct.
And it doesn't apply to the NCAA, correct? The NLRB opinion does not say that the athletes are employees of the NCAA. It says of the private university, correct?
Well, that's correct.
Are you aware of you were referring to some state court cases earlier on. Do those opinions, I believe they're out, one was out of California, maybe one out of Colorado, do those opinions say that a student athlete is the employee of the university or the NCAA?
Object to the form for multiple reasons.
What's a student athlete?
What you were calling a worker.
Oh, I call him a worker.
Yeah.
So I'm not going to accept your fake construct of student athlete. So I don't know what you're talking about when you ask a question, including the word student athlete, because it's a made-up construct to stop worker compensation suits.
Is it okay?
I don't have to accept your definition of what these people are. I make my definition of what these people are, which is the one that Byers agreed to, and he was the head of the organization during the relevant time period.
I think I've also referred to them as athletes earlier, and you didn't seem to have a problem with that. So, are you aware of the opinions that you cited to earlier, I believe out of Colorado and California, that they held that the athletes were employees of the university, correct?
Object to the form and object to the sidebar and move to strike.
I don't recall.
You recall if those opinions said that the athletes were employees of the university or the NCAA?
Object to the form.
I'm sure they didn't say the NCAA.
You're sure they did not say the NCAA?
That's correct. Can you pour me some water, please?
Do you know whether the University of Texas had physicians at practice or at games from 1967 to 1971 on the sidelines?
Not from personal knowledge.
Do
I
you know-
think from what I read, they did not.
That's what you read?
I think so. I don't recall specifically.
Do you know whether trainers at the University of Texas between 1967 and 1971 had the latest information regarding CTE as of that period?
I do not know.
I'm sorry?
I do not know.
Do you know whether the team physicians at the University of Texas were up to date with the latest information regarding concussions as of 1967 and 1971?
Yes?
You do know that?
Sure.
And were they up to date as of 1967 and 1971?
No. They couldn't be. You had the information and it was secret. How could they know about, for example, the helmet study? You have the information. They can't know what was available.
I'm sorry. I said concussions. I didn't mention helmets.
Okay, I'm
Hold
sorry.
on. Is that a question?
I'm sorry. Helmets are part of the concussion issue. Some people thought concussions could reduce, helmets could reduce concussions. Now, we all know that's not true now, and we know you knew it wasn't true then. But the team physicians might not have known that because the propaganda was that they would reduce concussions. So if you include the propaganda plus the fact that you knew that they were defective helmets, your word, not mine, then they didn't have that information.
You recall earlier we were talking about sources of information that were generally available, like the medical journals and medical textbooks and trade publications. Recall that?
Yes?
And do you know whether the team physicians at the University of Texas between 1967 and 1971 were up to date with the latest information available regarding concussions from those medical journal articles and medical textbooks and trade publications and things like that?
Haven't seen any testimony of that, I don't know.
Do you know whether the trainers at the University of Texas between 1967 and 1971 were up to date with the latest information regarding concussions as of that time period?
No, I do not know.
Do you have any contemporaneous evidence indicating that Mr. Pletz experienced dizziness from playing football at the University of Texas?
No.
Do you have any?
As I sit here today, I don't have all his medical records.
Do you have any? Well, let me try to short circuit this. Do you recall seeing any medical records from the University of Texas regarding Mr. Pletz's time at the University of Texas?
No.
So do you have, if I went through a list of symptoms like ringing in the ears or disturbance of vision or headaches or drowsiness, pains in the eye, you have not seen any medical records from the University of Texas indicating that Mr. Pletz had those symptoms?
Object to the form. Please don't misrepresent the record to him. You don't have records to show he didn't either. We don't have any medical records from the University of Texas.
I understand.
Then don't misrepresent it to him.
My point is simply
There are no records. That would be the point, not you looked at the records and it's not there, which is what you're trying to convey.
No, I'm not. Let me be clear. I'm just saying you have not seen them. Whether it's, they don't exist. I haven't seen them either. But my point is, you haven't seen medical records from the University of Texas during the time that Mr. Pletz played there that he suffered from ringing in the ears or disturbance or disturbance of vision or headaches or drowsiness, correct?
Object to the form.
I have not seen anything that does not exist, if that speeds things up. If it doesn't exist, I do not have supernatural powers. I have not seen anything that doesn't exist. If that will speed things up, I will concede that right away. So if you go through a list of things that don't exist, I will tell you what I started to tell you here. I haven't seen them. And I do not know everything that doesn't exist. Okay? So there's a lot of things that don't exist that may never have existed or may have existed and disappeared. I don't know about them. But if they do not exist or have not existed in the last several years after this case started with respect to Mr. Pletz, I do not know. I have not seen them. Hope that speeds it up.
You bring up a good point, and it's a pretty good segue.
Well, before we go on that segue, how much more you got? Because I want to go eat.
Not much more.
What's that mean?
It's going to behoove us to just wrap this up now.
Well, how about just
No, I wanna
answering his
know-
question?
How about answering my question? Because I'm going to take a break.
10 minutes.
Go ahead. In 10 minutes, we're going to take a dinner break.
We were looking at Exhibit 16 and 17 and 18. These are the documents with, it has NCAA knowledge across the top.
Yes?
You know what I'm talking about? And there's, for the source material, you have dates on here. There's a variety of dates, correct?
Yes.
You'll agree with me that, just as you were saying, you don't know about things that don't exist. You'll agree with me that the NCAA can't know about a document until it exists, correct?
Back to the form. You got them on that one, I'll give that to you.
Yes.
And the NCAA can't know about a study until it exists, correct?
Yes.
And by study, I mean the NCAA can't know about a medical study that doesn't exist, correct?
Yes.
Or until it occurs, right? So if a medical study doesn't happen until 2010, the NCAA is not going to know about it until potentially 2010 at the earliest.
Well, then that's a little more complicated question
Let me
than
clarify.
than the other questions.
Let me clarify.
So that's a little tricky, that question.
I understand. Let me clarify. If a study is not concluded until, let's say, 2010, then the NCAA is not going to know the results of a study at least until the study is concluded, correct?
No, not necessarily.
If it's a study that's never been done before.
That's a different question. If a, s-
Let me ask you this way.
I mean,
if
that's a metaphysical question, that last one. I don't think I'm qualified to answer metaphysical questions.
If- let's assume with me that the NCAA
Yeah.
is not, with all the documents and articles I'm about to talk about, the NCAA is not involved with authoring it or anything like that, okay? Or participating in a study or anything like that, okay? Are you with me?
Yes?
For a study of that type or an article of that type, the NCAA can't know about an article that has had nothing to do with until that article is at least published, correct?
Not necessarily.
The NCAA can't know about an email until that email exists, correct?
Yes.
And the NCAA can't know about well, I just asked that one. Sorry. Do you know exhibit number one? Do you know what exhibit number we're on?
45.
Do you,
So the next one's
include
46?
marking the,
Yes,
hard
yeah.
drive?
44 was the hard drive.
So my number is 45?
Yes.
Dr. Eagleman, I'm going to hand you what's been marked as exhibits 45 and 46. Those two documents are cited in your report, correct?
I don't recall specifically, but it looks like it. I got a lot of sites, I've memorized them all.
Exhibit 45 is a letter from, if you look at the second page, it's a letter from Kenneth M. Visti, MD, President of the American Academy of Neurology, correct?
Right?
And it's also signed by George Zitney, President and CEO of the Brain Injury Association, correct?
Right. Yeah, I remember this document now. Go
And
ahead.
it's also signed by the president of the American Association for Neurological Surgeons, correct?
Yes.
And it's an email dated August 27th, 1996, to Cedric Dempsey, right?
No.
It's a letter dated August 27th, 1996, addressed to Cedric Dempsey, correct?
Yes.
And attached to it is Exhibit 46. And you'll see down at the last paragraph of the first page, it says, "Please take a look at the enclosed draft copy of the American Academy."
Whoa, 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 whoa. Which, you
Oh, I'm
on
sorry.
46
on
or 45?
On Exhibit 45, on the very first page.
Okay.
Last paragraph on the
Yep.
bottom.
I'm there.
The first sentence says, "Please take a look at the enclosed draft copy of the American Academy of Neurology's practice parameter on the management of concussion in sports, as well as the draft palm cards for coaches and trainers." Did I read that correctly?
Yes.
And is Exhibit 46, to the best of your knowledge, what that sentence is referring to?
And I don't think this is I don't think the cards are here. Oh yeah, the cards are there. Yeah. Yeah, that's both. Yeah. Looks like there's some cards at the back.
You can, you might know off the top of your head, or you'll probably want to review it. Is there any mention in either Exhibit 45 or Exhibit 46 of CTE or punch drunk or dementia pugilistica?
I don't recall. I have to read them to know that.
Okay. Well, the first paragraph of Exhibit 45, the letter starts. I'll let you catch up.
Go right ahead.
It says, "As you know, the pressure to win can cause an athlete, amateur or professional, to forsake personal safety. Too often, coaches, owners, fans, and family expect and sometimes demand that an injured player tough it out and play through the pain, perpetuating the notion that an athlete who sits out to nurse wounds is weak, selfish, and unwilling to sacrifice for the team," correct?
You read it correctly.
Okay.
I think it's also a correct statement.
And then in the third paragraph, well, the second and third paragraph, and really the rest of this letter, expresses a number of concerns about concussions, right?
Okay, well, I need to read the whole. I'm not going to answer a question like that without reading the whole letter.
Well, let me point out a couple things and at least get the gist of it. On the second paragraph, the second line, it says concussion. Are you with me? The sentence that starts with concussions.
Yes.
It says concussions, the most common form of damage to the brain, are being overlooked as one of the most serious health problems facing amateur and professional athletes. Did I read that correctly?
Yes.
And then on the third paragraph, the very first line, it starts, "Concussions have ended careers and affected lives away from competition." Did I read that correctly?
Yes.
And then the fourth paragraph, it says, "Part of the problem is that coaches and trainers are simply not equipped to properly handle a player who suffers a concussion." Did I read that correctly?
Yes.
So from reading those few lines, it's fair to say that this document at least expresses some concerns about concussions, correct?
Yes.
Okay.
In part.
If you'll assume with me, and you may not, that
I'll assume anything you want me to assume.
Okay, well, let's assume in Exhibit 45 and 46, there's no mention of CTE, there's no mention of punch drunk, there's no mention of dementia pugilistica, okay?
Yes.
Am I to believe that the president of the American Academy of Neurology and the president of the Brain Injury Association and the president of American Association of Neurological Surgeons didn't care about those problems?
Go to the form.
I can't answer that question.
Why can't you answer that question?
The question says, am I, referring to you, to believe?
Okay.
I have no idea what you could believe. I never met you before. I don't know what your knowledge and understanding is of these issues. And even if I did, I wouldn't know how to know what you believe about something.
Would you tell the jury that the president of the American Academy of Neurology and the president of the Brain Injury Association and the president of the American Association of Neurological Surgeons, as of August 27th, 1996, did not care about CTE or dementia pugilistica or punch drunk as of August 27th, 1996?
Object to the form.
No. Well, no, not at all. I haven't read this document. But
Well,
no.
you're assuming for me that it doesn't, this document doesn't reference either of those three things, any of those three things.
That's right, but it may reference them in another way. It may not use those words, but it still may describe those effects.
So,
So in order to know, so your assumption doesn't comprise all of the information that might be in these two documents.
so in other testimony, when you've looked at documents and pointed out, well, there's nothing in the rule book that says concussion, or there's nothing in the rule book that says CTE, is it possible that those documents reference concussions in other ways, or try to protect against concussions in other ways other than using that actual word?
Object to the form.
Anything is possible, but I would assume if that were the case, you would have cross-examined me with that information here.
Excuse me, Chris, where are we on time?
We're at 11 minutes, so we're going to take a break.
I'd like
Well,
to
I
know-
might, if
I'd
you
like
get,
to know what he has.
if you give me a second, I might be able to end it with.
Well, and then it's no problem. Then we will take a break. If you're ending it, we can leave.
If you, yeah, well, give me a second to review and
Go right ahead.
confirm.
Take your time. Diego, could you pass these to the court reporter, please?
Well, we got this whole pile here, so we'll, I guess those are stamped differently, so make sure we don't lose those.
Those are gonna be very hard to say.
What'd you say?
Those are gonna be very hard to say.
Save?
To keep and bring back
Well, are those exhibits?
no, the small version is not.
Okay, so we don't need to save them.
Okay. David says we don't need to save them. We don't need to save them?
No, I'm not attached to them. We can. Those are like couple of bucks each to print. They're black and white.
Helene wanted the wallpaper of the kitchen with those.
So you could
Same
just strip
with-
them off.
Same with the all the soft ones. I think we can get rid of.
Yeah.
We have hard versions.
Yeah.
Yeah, no, that.
I mean, unless you
Okay.
want me to autograph them.
2 topics, 3 questions maybe.
The topics could be all your time.
It's not, it's worth it to just end this here. Trust me, it's gonna be way worse to leave and come back for this.
Go right ahead.
40 minutes.
Okay, thank you.
I'll be less than 20 minutes, don't worry. We're back on the record?
Yes.
Can we, I know y'all are packing up, but, thank you. Dr. Eagleman, do you have any evidence, or have you reviewed any evidence that would indicate that the coaches or team physicians or trainers at the University of Texas knew Mr. Pletz suffered a concussion and allowed him to continue to play and practice or during a game?
Object to the form to all four, I think it was 4 questions.
No.
Let me break it up. Just
No, it's okay. I answered. It's okay. It won't be different if you ask 4
I
questions.
understand.
I'll
but
withdraw the objection.
Okay. You testified earlier about, not with me, but you made mention of the NCAA making money and revenues from the NCAA. You remember that?
Yes?
Do you know whether the NCAA makes money off of college football?
At the present time or historically?
Either.
At the present time, I'm not sure. Historically, sure. When the divisions went independent and cut their own deals with the TV stations, the NCAA took a hit because each the divisions took the money.
Do you know when that occurred?
I don't recall specifically. I think after Mr. Pletz, though.
So certainly as of today, though, the NCAA does not generate revenue based on college football, correct?
I don't think that's correct. No, it's part of their general image, and it's part of the reason they make money. I haven't looked at that question. Okay, but they're all about money in general.
The NCAA does not own the college football playoffs, correct?
That's correct.
And
It's not like the Final Four; they own them.
And the NCAA does not own any of the bowl games, correct?
That's correct.
And revenue from home football games, for example, at the University of Texas, goes to the University of Texas, correct?
Object to the form.
I don't know.
You don't know one way or the other.
Correct.
You referenced this earlier, I think, the Lilly case. Have you ever been sanctioned by a court?
No.
You got into a legal dispute with Lilly over the unauthorized disclosure of documents, correct?
Yes.
And you obtained those documents because you were designated as an expert witness in a lawsuit against Lilly, correct?
Correct.
And then you disclosed those documents, and Lilly filed a claim against you, right?
No.
They didn't file a lawsuit against you?
No.
Did they send you a demand letter?
No.
A cease and desist letter?
No.
Well, there was some sort of dispute with Lilly because you entered into a settlement agreement with Lilly in which you paid them $100,000, correct?
No.
You were supposed to pay them, and they directed you to pay a charity.
No.
You paid a charity to settle. You paid a charity $100,000 to settle a dispute with Lilly over the disclosure of documents, correct?
No.
What was the dispute with Lilly regarding the disclosure of documents?
What was the Lilly alleged that I signed a confidentiality order and violated that order and released the documents.
And how did they allege that?
How did they do that? In arguments before a court?
Okay. And as a result of those arguments, you entered into a settlement agreement with Lilly, correct?
No.
You did not enter into a settlement agreement with Lilly to pay $100,000?
Objection to the form. Asked and answered, I think, 4 times.
That's not quite correct, that last question.
What's
Can't quite agree with that.
What's incorrect about it?
Well, I entered into a settlement agreement with Lilly, but to pay $100,000 is not the entire scope of the settlement agreement, and it was not. So that's part of what it is.
As
There
par-
was a whole long settlement agreement.
As part of that settlement agreement, you paid $100,000, correct?
$100,000 were directed through Lilly to a charity. And are you done now?
I know Gene's going to push back on this. I am ending my questioning now. I am not closing the deposition. I'm reserving the right to go to the judge to ask for more time based on the extended answer this morning. But as of right now, I am not going to ask you any more questions.
You didn't even-
Okay, well, you have another 40 minutes
You didn't even
right
use all
now.
your time.
You have another 40 minutes right now,
No, he doesn't have that long.
Do
or
you,
whatever you have.
But
do you, I can stay here if you want and ask you another 40 minutes of questions, but you told me you wanted to go to dinner.
you don't have
And-
40 minutes left anyway.
Well, I was just going off of what he said. So I'm trying to
Bottom line
accommodate.
is you have time left, and obviously I don't agree. Doctor, I have three
Wait,
questions.
let me finish this. You have time left. I said I wanted to take a dinner break if you wanted to go longer. Okay? You have that option. It's 10 minutes of 9. I've been here since 9:30 in the morning. Okay? I had lunch about, I don't know, 8 hours ago, 9 hours ago.
As
okay?
did I.
Great. Okay, so I just want a break to eat something, and I'll be glad to let you finish
Are you passing the witness?
churning your questions. No problem. Okay? Anything you want to do, I'll be glad to do, but I just want a dinner break, which I think is a reasonable thing, okay, after having gone all day long.
And I will do you one better. You can have dinner and go home. I am simply reserving the right to go to the judge to request more time.
No
That's all I'm
problem.
saying.
You could.
Judge,
I don't have anything to do with that, right? That ain't my business.
Fair.
My business is to sit here until you exhaust your questions up to the legal limit, and that's what I'm willing to do. But I'm not willing to do it in a marathon. It's late. I'm tired. I want to take a dinner break. You want to go ahead? No problem.
I am not reserving my right because you want to go on a dinner break. So just to be clear about that.
What? Three questions, Doctor. These. I
By the
think-
way, you don't get any different than him. If this is going to go more than a minute and a half,
I said
we're
three.
out of here.
That's good to know.
I said, believe me, and he means it too.
Okay.
These 450 times or days or whatever that you've testified, how many times has the court said you couldn't testify?
Once.
And did you use the same kind of methodology in those other 449 times that you've used in this case,
Objection form.
generally speaking?
Objection
Well,
form.
Looking at corporate documents, testifying about the history, that sort of thing?
I didn't do that
Objection
in all
form.
the cases. I mean, I did different things in different cases, but a lot of times I've testified doing this same comparison. Basically, what I do is compare the information available to a company, or in this case, the NCAA, to that's available to the general medical and scientific community.
Have you testified in Texas before?
Yes.
Has any Texas court struck your testimony?
No.
Second thing, doctor, you got asked a lot of questions about what did UT know, what did a doctor know, what did somebody else know. Does any of that serve in any way to change your opinions about whether or not the NCA violated its responsibilities?
No.
Third, do you recall the question being asked, something to the effect of, if the NCA does the right thing, will it do Greg Pletz any good? Do you remember that question?
Yes.
Does
Objection
that,
form.
does that question in any way relate to the opinions you have in this case?
No.
Okay, that's all I have. Thank you.
I think one follow-up. The with regard to the questions about what the coaches are doing and the trainers are doing, and whether that would alleviate the NCAA's obligation. Would you agree with me that there is, and I think you've testified about this in other cases, sort of a warning, would you call it a warning system or a warning program where multiple pieces are working together. Does that ring a bell?
Well,
Check to the form.
I didn't use those terms. I think I know what you're talking about based on my construct of warnings. What I've said is a label is, I refer to the 1939 documents of the Paint and Varnish Association, which lays out that warnings are not limited to a label. They involve education through salesmen, through point of sale information, all kinds of things. So that was my testimony generally, is to say that a label is generally not a sufficient warning on a product.
And so part of the warnings here would be potentially warnings from the trainers at the University of Texas between 1961 and 1967 and 1971, correct?
And ask and answer.
The question doesn't make sense.
Well, are you aware of any warnings that the trainers at the University of Texas gave Mr. Pletz?
No.
What about warnings that the team physician gave Mr. Pletz at the University of Texas?
What about? That's not a question.
Do you know what warnings the team physician at the University of Texas may or may not have given Mr. Pletz?
No.
And what about warnings from Coach Darrell Royal that he may or may not have given to Mr. Pletz?
Check to the form, asked and answered.
That's not a question that can be
Are
answered the
you
way you
aware
framed it.
of any warnings that Coach Darrell Royal gave to Mr. Pletz during his time at the University of Texas?
No.
As I said before, reserving my rights, but no more questions.
All right.
This concludes the April 12, 2018 deposition, portion of the deposition of Dr. David Eagleman. Going off the record, the time is 8:56 p.m.